If you're separating from your partner and you've never been married, you may be worrying about how you're going to set up sensible financial arrangements between you. And that may include making provision for your child together. Many people reach agreement just by working it out between themselves what is for the best. Others reach agreement when they've been able to explore the legal backdrop. And others rely very much on this system of legal rights and obligations to get to their conclusion. You may have other systems to consider, for example, whether issues of protection, which have difficulty agreeing parenting arrangements. But just focusing on the financial aspects, this system of legal rights and obligations is actually three systems. First, there's property claims, which people call tellata, often referring to the Act of Parliament that deals with them. It's broadly a system that looks into the past to assess what promises have been made between you relating specifically to this property that should now be honoured. These are routinely what you wrote down when you understood between you what you were going to do with the property, or more controversially, what may have been promised between you since then in relation to the property or assets in one of your names. Secondly, you have the administrative system of child support run by the government agency, the Child Maintenance Service. There is a formula and an administration and appeal system that decides what income one person, the non-residential parent, should pay to the other, the parent with care. This would be a maximum of around £15,000 for one child, £20,000 a year for two children, or £25,000 for three or more. And it will reduce where the paying parent earns less than £150,000 gross, or they have overnights with the child, or have other children living with them, or all that they're paying to support. You can find a calculator on our website to help you work out the answer, but there's quite a lot of detailed structural rules that you might need to be aware of as well. And the third system is a bit of a safety net scheme, which you will often hear referred to as Schedule 1, which refers to the statute again. It's often not terribly well understood, but you will find, for example, binding arrangements made under this umbrella that deal with educational costs, or perhaps provide housing, where one party has substantial assets and the other insufficient to house themselves. Or it might fund the equipping of that home or provide a car, or might deal with general maintenance for the child, where the paying parent earns more than that £150,000 a year. So where you find yourself getting stuck in your discussions around the finances or parenting, the solicitors here at FLiP are very happy to talk through the detail of how these systems are likely to apply to you. The financial ones will be tellata, the financial partnership between you, CMS, the general support paid for a child under the state formula and system, and the discretionary court system called Schedule 1, which provides help with a child's financial needs not met by the other two schemes. When we know the answer between us, that may or may not be enough. And if you still haven't landed the agreement between you and your former partner, then sometimes you will need to go further and have help with the process by which you will get things to a conclusion. But reach out. Sometimes what feels pretty impossible we can help you get sorted without too much input. But be careful about hanging on too long just trying to find that agreement that's eluding you, because things can start to become impacted. We're here to help you before you get to that stage.